Hi, everybody. Thanks for joining today. We're going to start our LLC structuring 0 to 60. Just a little word about the meeting, a little introduction. See the picture of this car. Structuring deals and entity structures can be very different, and there are a million ways to structure it. They're all right. It depends exactly what you're doing, what your goals are. What we're going to do today is not teach you how to structure things, but we're going to go through some of the fundamentals of structuring, what goes into it. And then we will go through some basic structures, which again, just they're blueprints for how things are done in different scenarios. And of course, there's lots of different variations. Each lawyer has their own style, and each deal has their own nuances, which make them special or unique. Now, just a little disclaimer, I am not a real estate lawyer. I'm not a securities lawyer. In fact, I don't even practice law today. I am just sharing the information that I know. Whatever you hear over here, speak to your lawyer. If you are a lawyer, then you are a lawyer, or speak to your CPA. They will give you professional advice. This is just to educate you and to open up a window into LLC structuring, to uncomplicate it and make you familiar with it. So we have a framework that we'll use to develop for determining the entity structure. You can see an image over here. The first thing is you have to define your goals for the deal. Now, again, we're talking about real estate here. We're not talking about any other businesses. This is all about real estate. So you have to define your goals, what you want from your entity. You have to, after you know your goals, then you want to choose the appropriate entity. Then you want to determine the best state for the formation. Now, all these things are great, but typically, or very often, if it's a more complex deal, it's not just about choosing one entity. It's about choosing a whole structure of different entities in order to get to where you need to get to. So once you have these three bedrocks, then you can create the perfect structure for whatever business you're doing. So let's define some of the entity benefits and what your goals may be. The reason why we have corporate entities is because if you have you can do business as a sole proprietor, but in that case, you would be personally liable for everything that happens. So the first thing about entities, or at least the entities we'll be talking about, are they limit the liability. An entity is not you. An entity, according to the law, is a different person. It's an entity, and it's not connected to you in any way. Therefore, whatever money is in the entity is what you can sue the entity for. You cannot come to the owner of the entity and take money from them in most cases. But there are exceptions, and keep in mind that entities are formed on the state level. So there's no uniform law across all the states. Each state has their own nuances on how the protection is, what level of protection there is, and what's protected. So the first thing you need to know is about asset protection. Asset protection means you're protecting the assets from being taken over by somebody else. Or there's a few ways to look at asset protection. There's the assets inside the entity. that you don't want the people suing you personally to be able to get to your entity, and you want to make a separation between you and your entity. And the other part of it is you have your own personal assets, and if somebody's suing your entity, you don't want them to be able to get through that entity at your assets, at your personal assets. So the inside protection is protecting from an inside suit. You have a building and your boiler explodes and somebody sues you because of it. You want to make sure that the only thing they can take away are the assets of the LLC that that building is inside of, and not you. So the only way they can actually get at you is by piercing the corporate veil, which means that you have a corporate veil that protects you. It's a structure. It's like a wall between you and the entity. But there are times that the courts will allow them to break through that wall and take away your and sue you personally. Now, each state is different, and some states will let you pierce it a lot easier than others, which is why you have to see exactly what state you're in. And then there's the outside protection. If you are driving a car and you crashed into somebody and you had no insurance and they sued you personally, so you want to prevent them from taking any of your real estate holdings. So you put them in an LLC. The LLC is not you. They can sue you, but they can't take anything from the LLC. That's called outside protection. And there's a law called charging order protection, meaning that the fact is that you own the LLC and you get distributions from the LLC. So while the court will not allow you, the person suing you, to take away your part of the LLC, your partner, your membership units, but they will allow them to take your distributions. So if any money is distributed to you, that means it leaves the LLC, it goes into your personal bank account, and that's fair game for anybody who sues you personally. But again, we're not going to get into it in this webinar. We'll have other ones on asset protection. There are ways to make sure that nothing comes out to you without harming the regular distributions of the LLC. And then there's another problematic LLC called single member LLCs. The idea of not allowing somebody to get the assets of the LLC when you personally did something wrong make a lot of sense when there are a number of people in the LLC. So I'm a partner in a business with somebody else, with Jack, and me and Jack have a building. And now I did something and somebody wants to sue me. It wouldn't be fair. The court said it wouldn't be fair for them to take the assets of the LLC, because not only is it a separate entity, but it also belongs to Jack. It's not even me alone. But what happens if I have a single member LLC? I'm the only owner of that LLC. So courts have determined that single member LLCs don't have charging order protection. It belongs to me. I'm the only member. We're not disrupting anything except my personal finances, and therefore the LLC's assets can become fair game. So you have to know what state you're in, and you have to make sure that you have single member LLC protection. These are the states that have charging order protection, even for single member LLCs. That's Delaware, Nevada, Wyoming, South Dakota, and Alaska. You'll see these names coming up a number of times because we have good states for LLCs, and generally they're good for most things. And then we have states that are less good for LLCs, and they're stricter for a lot of things as well. What's interesting is that Florida and Texas, which are generally good states for LLCs, have determined that single member LLCs don't have charging order protection. And if there's a sole member of an LLC, you can actually take the assets of the LLC if they can't pay you off with their own assets. So that's the first part, asset protection. And you want to take a look at that when you form an LLC. The second thing is privacy. Now, privacy is very important for a very simple reason. If you are sued and there's a judgment against you, the court will make you write all your assets. You cannot hide assets. Even if you have anonymous LLCs, you will have to declare all your assets. And if you don't, then you have violated the law. But there's a catch to this. The catch is that a lawyer will sue you. But if somebody comes to a lawyer and says, okay, this guy hit me, it was a car accident, I want to sue him for $1 million. The first thing the lawyer will do is see what the insurance policy is. The insurance policy is $100,000, but this guy wants to sue for $1 million. So he's not going to settle with the insurance company. The lawyer will do a quick search or a detailed search to see what assets you have personally. If you don't have assets, the lawyer is not going to waste his time suing you. If they do find that you have assets, then they'll go after you. More than that, if you have a lot of assets, you actually become a target. People will look for reasons to sue you if they know that you have a lot of assets. So while you can't hide it from the court, you can hide it from the lawyers before the court case starts, because the lawyer can't ask you for your assets until he wins a court order. Until the judgment is against you and he has a court order for a certain amount of money, that's when they begin to do an asset search. So if you hide your assets, no lawyer will go after you because it won't be worth their time. They're taking a gamble. They're doing a lawsuit and hoping at the end that they will find some money. So you want privacy. Now, when you form an LLC in many states, they ask you a lot of questions, or not so many, but they ask you questions that could divulge your identity. They want to know who the members are, and any state that asks you for the members, that goes into the public record, everybody will know that you own that piece of property. They'll ask for manager details. They'll ask for registered agent. So you can be technically, you can be your own registered agent in a state that you have an address in. A lot of people don't want to be that because they want to maintain their anonymity. So even if it's a state that I can be, it's worth the $150 or whatever it is you have to pay for registered agent service just to get your name out of the database. They can ask you for a principal place of business, and that will often be a clue, and people will be able to look who owns that principal place of business, who works there, and to be able to find out your identity. So if you do all these things right, or you go into a state where all these things are kept private, because some states make you divulge, some states don't make you divulge. But let's say you went to a state that, like Wyoming, okay, Wyoming or Delaware, Nevada, where you can keep all this information out of the public database. Now, a lot of people, unfortunately, after they've done that, because they worry about their privacy, they make other mistakes and they divulge their identity that way. So you have to be careful. First of all, if you have an affiliate company, an affiliate LLC that's both owned by the same Wyoming holding company, and the affiliate company has your name on the record, then people will be able to see that that affiliate is owned by the Wyoming entity, and they'll be able to figure out that you actually own all the entities that are owned by the Wyoming entity. Where does this come up? People, beginners especially, they'll buy it in their own name. Then they'll move it to an LLC, and only then will they form a Wyoming LLC. Even though they moved everything around and they changed their identity, but it's already on record that they were the first owner. And once it goes on record, it doesn't ever get erased. You can see that it was transferred to an LLC, and then the whole thing falls apart. The whole construction crumbles, and they can now figure out who you are. So you have to be careful. People, when they buy their first property, they want to save some money. They don't want to form a proper structure, but at the end of the day, it costs them more money and possibly even their anonymity. A lot of times people on social media talk about properties, or they have websites. You have to be careful about hiding your name over there as well. And then business operations. We'll get to this in a structure a little bit further, what this means to be careful with business operations. So now we have asset protection and privacy. Our next one is taxes. So one of the structures, some of the structures make you pay self-employment taxes, and some of them don't make you pay self-employment taxes. That would be very important, especially if you're in real estate, and we'll see that in a couple of minutes. There are different states that have state income taxes. Some don't have state income taxes. They're franchise taxes. There's also the cost of forming entity in states. Some of them have annual fees that are higher than others. Some of them have gross receipts taxes. So you prefer to be in a state that has less fees. The states, but the most important one is the state income tax. And again, we have the ones that don't have state income taxes. This is the ones we saw before, plus Florida, plus Texas and Washington, Texas and Florida. Those are the new ones to the list that don't have state income tax, even though they don't have charging order protection. Lastly, there's probably more considerations, but the last one that we're going to consider here today is capital raising. When you form an LLC, part of the reason why you form an LLC is because you want to raise money for a deal, and you want to do it in a way that you'll be able to attract more capital. So one reason you have an LLC is because no investor will give you money directly. They'll only invest in an LLC where they know that they're protected and you can't do anything. They can control the money. But that would also go to the fact of which state you would form the LLC in. Delaware is known as, and people have this impression of Delaware being a fabulous state because most of the corporations are formed over there, but that really doesn't have anything to do with LLCs, but it does have a good reputation, which is why a lot of people register their LLCs in Delaware. Then there are lender requirements. Now, the lenders certainly want to be in Delaware, and we'll talk about that in a minute. And then there's a robust court system. So let's talk about Delaware, because Delaware is where the capital raising happens. The Delaware courts have a long history of corporate law. Now, LLCs started, the first state that adopted LLCs was Wyoming in 1977. It took until the 1990s until every state allowed a structure called an LLC. And therefore, when you have states that have less LLCs and everything is bunched into the court system, the judges there, when they get a question about LLCs, don't always know what they're talking about. They're not very well versed in it, and they don't have in their head like how we deal with these cases. But the Delaware court is, first of all, Delaware is separated. They have their own business court. So the judges there are all business judges, and they know business, number one. Number two, they have a very long history of corporate law. So therefore, the corporations know exactly how cases will be decided in Delaware. It's not a guess. When you go to a state like, I don't know, Tennessee or New Mexico, you never know what the judge is going to think that day because there's no precedent in that state. But Delaware has precedent, and therefore it's more predictable what the courts will judge, and they happen to be very pro-business. So the lenders will typically force you, if different type of lenders, different type of loans, they will force you to have a Delaware entity that they will loan the money to because of these reasons. So now we have our 4 reasons to choose an entity. Let's take a look at some of the entity choices. So the older one and more popular, especially since LLC is relatively new, is a limited partnership. Limited partnership is just that. A limited partnership means that there's at least one general partner. The general partner runs the business, and he's the businessman. And then we have one limited partner. The limited partner is limited. The only contribution that a limited partner can have to the limited partnership is giving money. They have no say, they have no control. If they do, so what happens is the limited partner has liability protection. You cannot sue the limited partner because he's just a money partner. You cannot sue him for more than the assets that he has. He can lose all the money he has in the deal, but he can't lose anything more than that. The general partner, you can sue the general partner personally because he's running the business, and therefore he becomes a target for a lawsuit. GP is personally liable. Now, what do GPs do? No GP in his right mind would allow personal liability. But the GP in a limited partnership can be an LLC. So rather than, if I was the general partner, I wouldn't go in and be a general partner of a limited partnership. I would form an LLC, and then I would have my LLC be the general partner. Therefore, I have liability protection from the LLC. That means that nobody can sue me personally. They can only sue my LLC. And the LP cannot be involved in the decision-making or management. If an LP is proven to be involved in the decision-making and management, then you can sue them personally. Now, what's also very important is that a limited partnership is considered a security. And we'll explain why that's so important in a minute. Let's look at the limited liability company, which is much more popular today for real estate deals with syndications. These are the benefits of the limited liability company. First of all, it has excellent liability protection for everybody inside, whether you're a manager, whether you're just a passive investor. It has asset protection, which we've discussed. It has flexible rules. Now, all states have rules for limited liability companies, but the rule is that those rules are only by default. Almost all the rules of limited liability companies you can change in an operating agreement. The operating agreement is the Bible. It makes the rules for the LLC, and each LLC has its own operating agreement, and therefore it's run differently, whether it has to do with dissolution, bringing in partners, management, what control managers have. They could even have different classes of shares. You can have one class that votes, one class that doesn't vote, one class that has a certain amount of distribution and one class that has different amount of distributions. You can do almost anything you want with an operating agreement, which is why everybody likes it today. You can even have somebody, you could even take the profits and losses and say partner A gets 80% of the profits, but only 20% of the losses, and vice versa for partner B. The only condition to that is the government doesn't want people to play around to avoid taxes, so you have to prove that there's a reason for it, that there's a substantial economic reason for dividing it that way. But it's pretty flexible and it works. And then there are tax benefits that you have in a limited liability company. So now we have the S Corp, the most misunderstood entity from the entity menu. S Corp is not actually an entity. An S Corp starts out as either a corporation or it starts out as a limited liability company. So a corporation, we know, and we won't be discussing corporations today because for most people doing real estate deals, corporations are not an option. Corporations have, the big problem with corporations is that they have double taxation. They're taxed on the corporate level at 20%, and that's when all the profits stay inside the corporation. If you want to move a profit out of the corporation, then you have to pay dividend. Then it's called paying a dividend, and then people have to pay, the shareholders pay, they pay their capital gains taxes on any dividends they have. So there's double taxation. So the government has given an option to have a corporation taxed as an S Corp, meaning that it's run as a corporation with all the rules, with the whole corporate structure, but you can choose to have pass-through taxation, which means there's no taxes on the corporate level. But for all intents and purposes, the S Corp is a corporation without the double taxation. You can also have an LLC that has its own structure, has its own operating agreement, very different than a corporation, but it also wants to be taxed as an S Corp, and we'll explain why. The reason why an S Corp is advantageous for an LLC. If you have an LLC, so you are, every dollar you earn, you have to pay self-employment taxes on. So if you earn $200,000 in the LLC, you pay 15% on that money, or whatever the limits are, you pay self-employment taxes. If you have an S Corp, that means that you can give yourself a salary. You have to decide what value. It's not arbitrary. There's laws. You have to decide. There's a table of what value you give to the S Corp, depending on what services you give. And then your salary becomes that amount of money. So for example, if your S Corp makes $150,000 a year, your salary is determined to be $50,000. So the employment taxes only go on the first $50,000. That's considered salary. The rest is called passive income, and it's exempt from self-employment taxes because it's not employment taxes, it's passive income. Now, the reason why we don't use S Corps for real estate is because most real estate has to do with rental income. Rental income is passive, and being that it's passive, you don't pay any self-employment taxes on all your rental income because they're not employment taxes. Another problem, there's other problems with the S Corp. Let's go through them. So the main advantage of an S Corp is not paying self-employment taxes, which is an advantage for active income. If you have a regular business, it's great. But rental income is passive, so you end up paying more taxes if you have an S Corp because you would have to give yourself a salary. Now, another problem with S Corps is that when you have an LLC that's not an S Corp, you can distribute land in and out of the S Corp, and it's not called a taxable event. So if I have a land that I bought for $50,000, that's my tax basis. I put it into the S Corp, and it's now worth $150,000. That's not a taxable event. I don't have to pay $100,000 capital gains on the profit because nothing happened. It's not a taxable event. Similarly, if I move it out of the S Corp, let's say now went up to $300,000, and we move it out to different entities, then in an S Corp, that would be a taxable event, and the S Corp would have to pay $150,000 tax capital gains taxes because it came into the S Corp at 150 and it left at 300. So that's a capital gains tax. If you have an LLC that's not an S Corp, and we'll see later why you move things in and out, then that's not a taxable event, and it would go out to the new entity with the same basis of $150,000, and we would not look at what the value is today, and it would not be a taxable event. Another problem with S Corps is a very serious limitation. They have all kinds of shareholder limitations. You can only have up to 100 shareholders. You cannot have any foreign shareholders. You can only have one class of shares. An entity cannot be a shareholder. They can only be individuals. So you cannot invest in an S Corp if you're an LLC. You have to go in as a private person. As we said, there's only one class of shares. And more than that, we said that in LLC, you can have your distributions however you like. In an S Corp, there's shares, and distributions are distributed solely based on shares. So we see that an S Corp is not typically used for a real estate deal. We'll see later that in one case, it may be beneficial. Corporations, we won't discuss because, as we said, it's not typical for most people. Big corporations, actually, if you're doing big business, you're a corporation. But for most real estate deals, we're talking about LLCs. So the trend is while it used to be LPs were the favorite structure of real estate deals, today it's become LLCs. In an LP, you have total management control. You have known law. And an LP is a security. Whereas an LLC, you can have any amount of management control divided between the limited partners and the main partners, the general partners, as per the operating agreement, which makes it obviously much more appealing. Today's real estate investors are a little bit more shrewd, and nobody will really give their money into a deal without having any control whatsoever, without having any say, without having any voting rights. So that's why LLCs work better today. That's why it's attractive to investors. And an LLC, not in every deal is it a security. Now, securities is not really the topic of our webinar, but we will touch on it because it is an important point, and it does intersect with what we're talking about. So let's talk about why an LLC could be a security. And there are a lot of people that do LLCs for real estate, assuming that they're not securities. And if the SEC ever finds out about it, that's serious trouble because they would be considered securities and they did a security offering, not according to the rules. So the definition of a security is an investment of money in a common enterprise, meaning with a bunch of people together with an expectation of profit. And here's the key part of it: through the efforts of others, meaning that you are giving money and you're not controlling it, that somebody else is controlling it, which means that you only have a security interest in that venture. You're not a partner in that venture. Now, how do we determine the efforts of others? We determine if the person giving money has any involvement, what the profit sharing is like. Is there even profit sharing or is it uneven profit sharing favoring the managers? And what kind of control does the investor have? So typically, if there is serious control, even in an LLC, and you're just giving money and you don't really know what's going on in the deal, that would be considered a security, which means that you would have to register with the SEC. Once you register with the SEC, which is an expensive and hard process, you can offer the security to anybody. But the SEC has made things a little bit easier in order to get more business going. And they said, okay, we will make some exemptions to the securities law, and you won't have to file with the SEC except for one small document. But the reason why they have securities laws is to protect investors. So they would only let you, in these cases, offer your investment to either accredited investors or people that you're close with, that you know, which means that you can't advertise. And we're not going to get into it, but those are the exemptions of 506B and 506C. And then you would still need documents. You would need a private placement memorandum, subscription agreement, investor questionnaire, and you would have to do some filings, obviously not as expensive or detailed as the SEC filings, but you would have to file a Form D with the SEC, and then you would have to file in the state of your business or where the investors are from with the blue sky laws. So again, people should be aware of this when they do LLC real estate deals. They have to ask themselves if they're a security, if all the investors are relying on one person to do the work, or everybody is a part of it. Only if everybody is a part of it are they exempt, and are they not considered a security. let's talk about the states. Which state do you want to file your LLC in? So if everybody had their choice, they'd all run to Wyoming. Wyoming is the best state in the country to file their LLCs. They have the best privacy protection. They have the best asset protection, even for single member LLCs. They have charging order protection for single member LLCs. They very rarely pierce the corporate veil unless you've done, there's two ways they can pierce the corporate veil. One is if you did not run your LLC like an LLC, meaning that you commingled your funds. You didn't have all the document, you don't have an operating agreement, or you're not running it according to the operating agreement. And there are a number of formalities that you have to do. So in that case, they will pierce the corporate veil because they'll say you're not an LLC because you're not running it like an LLC. But if you follow the procedures, which are relatively simple and not very strenuous, they will not pierce the corporate veil unless you've done something criminal or negligent. So that's the lowest standard of piercing the corporate veil. I mean, any other state would pierce it for lesser reasons than Wyoming. There's no state taxes in Wyoming, although there is tax for Wyoming assets, but that's not what we're talking about over here. And the fees in Wyoming are quite low. Now, again, I'm a little bit biased because our business is forming LLCs and doing annual reports. But in my head, and this is, I think, an unbiased, consideration, LLCs are the cheapest part of your business. We're talking about a few $100s to form an LLC and a few $100s a year to maintain the LLC. And anybody that takes their business seriously, not to form or have an extra LLC or to form it in the right place, and even to have extra entities to protect themselves, to me, it doesn't. I never understood that. You're talking about big deals with tens or hundreds of thousands of dollars, but you want to save a few $100s on the LLC. It's a form of insurance. Nobody questions insurance prices. Why they question LLC formation, and that's exactly where they want to save $200 is beyond my comprehension. But I understand that it is a mentality and a lot of people have it. So yeah, enough said. Then there's Delaware. So Delaware also has very good privacy, not as good as Wyoming, very good asset protection, not as good as Wyoming, but you may have to file there because that's the lender's choice of state. And that's where if you want to get bigger investors, blue chip investors, that's the place where they want to put their money into. They want to put their money into a Delaware LLC, not some Wyoming LLC. Now, all this is very well and nice, but you don't really get to just open up a map, throw a dart at it, and decide where you want to form your LLC. Because if you are doing business in Georgia, you can't do business in Georgia with an LLC that's in Wyoming. You need permission. An LLC is permission from the state to do business in the state and to access the court system. So if you buy a property in Georgia and you buy it through a Wyoming LLC, the Wyoming LLC is the owner of the property in Georgia, and you have to sue somebody, you go to court and the courts will throw you out. I mean, I just had a case last week. Somebody called me up. They have a New York entity, they have a New York property, and they went to court to sue somebody. And they didn't publish. A lot of people think you don't have to publish. And the lawyer said that they can't sue them because they didn't publish. And the court agreed, and they threw them out of court. So you need to understand that LLC must be in the place that you're doing business. So to do business and access the court system, you need to have an LLC. Now, what you could do is you can foreign qualify your LLC. Okay, the things that would make you have an LLC in the state is if you have a nexus. That could be a physical nexus. Nexus just means connection. A physical connection, meaning that you have an office, warehouse, employees, and obviously a property. Or you have an economic nexus where you have sales volume or a certain number of transactions. This applies to Amazon people or people that sell online. They don't realize that they need to be filed in lots of states that they're not filed in. So what you can do is, if you want the benefits of a Wyoming LLC, and you need to have a local LLC in Georgia for the property that you're buying, the rental property you're buying, what you do is you form an entity in Georgia. But that entity in Georgia is not owned by you. It's owned by a Wyoming LLC, which means that you have the Wyoming LLC sitting between you and the LLC. So for asset protection, you still have the barrier, the Wyoming barrier that separates between you and anybody who wants to sue you. Okay, you also have the anonymity because the Wyoming LLC is anonymous. The Georgia LLC is not anonymous. They want to write down who the members are. But who are the members of the Georgia LLC? Simple, the Wyoming LLC. So you can go back to Wyoming LLC. The lawyer can, somebody wants to sue you, sees, okay, I'm suing this guy and he has a property, or I don't know, there's property in Georgia, but there's a Wyoming LLC. So we can't find out who the owner of this property is. Okay, if somebody wants to sue this property, they don't know who the owner is because it's owned by a Wyoming LLC that's anonymous. So that's, I think, the only 3 states that you have to know in entity formation. It's the state that you're doing business in. Wyoming is the best state. Delaware is a good state, but it's a state that will be forced upon you either because you think it's better for your investors or because the lender will insist on it. Okay, let's start diving into exploring structures. Let me just take a second to look, see if there's any questions in the chats. Okay, let's continue. So let's look at passive investments. Everything we said until now has to do with an active investment. When it comes to a passive investment, if I'm a member, if I invested in a LLC that has an apartment, that has a building in Georgia, and I'm a limited partner, I'm just a money partner, I don't have to have an LLC in Georgia because I'm not doing business in Georgia. The fact that I have investment in Georgia does not give me a nexus to Georgia. So what that means is that I could have a Wyoming holding company. Okay, I don't need a Wyoming holding company really. I just want to show you the 2 possible structures. You can do it like this. Let's say you have in 3 different states. You can be a member of 3 different LLCs in 3 different states in your personal name. You don't have a problem, theoretically. The reason why you don't have a problem is because as a limited partner, or either as a limited partner or a member of the LLC, nobody could sue you personally. They can only take your money out from the LLC. And if they wanted to sue you personally, if you had an outside attack, if you got into a car accident and they wanted to sue you, they wouldn't be able to break into the LLC. You would have charging order protection. Okay, so theoretically, you don't need a Wyoming holding company even for your passive investments. There are a couple of reasons why you may want to have one. First of all, you have better management. If you have a Wyoming holding company and you invest through your Wyoming holding company, you can keep all your real estate passive investments in one holding company to keep. Now, a lot of people will tell you that you should keep different kinds of investments, real estate in one, stocks and bonds in another, and each one should have their own Wyoming holding company. Now, another reason why you would want a Wyoming holding company, and we mentioned this briefly before, is that you have charging order protection. If you did not have a Wyoming company and somebody sued you, so he would sue, let's see the bottom picture, he would sue you and he would want to get after the assets of the LP. Now, the LP would have all kinds of problems because if the LP distributes you money, it would be taken away by your creditor. So typically what's done, if there's charging order protection, is we just don't distribute to you. But now you're asking the LP to change all the distributions and try to funnel out the money to you in another way, whether it's through salary or whatever it is. You're messing with the LLC, which may or may not care that you got into a car accident. And they may just distribute you your money, and they're allowed to, and then you lose your money to the creditor. If you're a Wyoming holding company, then you don't even have to get involved with the LLC or the LP. They would just distribute the money to the Wyoming holding company. It would sit there. You're the boss of the Wyoming holding company. You could choose when to make distributions or not. And you could just let the money sit as long as you want in the Wyoming holding company, and the creditor could not touch it. You can only take it with charging order protection once you distribute it out of your Wyoming holding company to yourself. So in that case, again, you could give out salaries for different things, and salaries are protected from creditors, or you could just keep it there, whatever you want. It would cause a nightmare for the opposing counsel, for the creditor to get your money, and it probably wouldn't be worth their time. So that's just one reason why Wyoming holding company would make sense even for passive investments. Okay, let's go to active investments. And this is a question I get very often. Somebody does their first purchase. So who buys the property? So typically I would say you should set up a Wyoming holding company like we discussed. Then you should set up the Wyoming holding company will form a local property LLC, which would be the title holder, which would take title to the property, and then you can be anonymous and you can be protected. So you would have your anonymity, you'd have your single member LLC. Even as a single person, if you just did the local property LLC, you may have asset protection problems and you would have a anonymity problem in most states. And you would have Wyoming law behind you. Now, what a lot of people do is the first thing they do is buy it in their name. And then they transfer it to an LLC. Now, the reason why they do that is because nobody will give, especially to a beginner, you form an LLC, no bank will give the LLC the loan on a property. Who's the LLC? Why would they give it to the LLC? They make you be a personal guarantor on the loan. I don't see what the problem with that is, because buying it in your own name, you're also a personal guarantor on the loan. But you can oftentimes get better rates if you do it yourself rather than doing it through the LLC. The problem with that is, and it's a consideration, something you should discuss with your bank or your CPA. The thing to consider is that if you transfer it, if you take a loan from the bank, you take a mortgage from the bank and it's in your name, and you transfer it to an LLC. When you transfer it, there's a due on sale clause in your mortgage that says if you transfer the property out of your name, then you have to pay the entire principal on the mortgage right then. So if interest rates went up and the bank's not happy with the interest rate you have, and they could get a better interest rate, you can't transfer it because they will do the due on sale clause, and then they'll make you take out a new mortgage under the LLC anyway. Second problem is you have title insurance, and title insurance is both for you and the mortgage lender. And as soon as you transfer it out of your name, it's under your name. And if you transfer it to an LLC, then you voided the title insurance. So that's usually not a problem. You can speak to your title company and they could just change the name for you. Another thing to consider, and this depends on what state you're in, is that you have a transfer tax. As soon as you transfer it from you to the local property, to the property LLC, you owe the state transfer tax, and that's a cost. And that's something that should be calculated in your entire equation to figure out if it's worth it to buy it in your name or not. Now, a lot of times people will buy it in their own name. They'll sign a contract in their own name because they want to do it quickly and they're not set up for LLC. And that's fine. They can buy it in their own name, but they should then assign the contract to an LLC before the close, because during the contract, there's no title transfer, nothing happens, and it's okay to transfer the contract to the LLC, and the LLC can take title directly, giving you, again, all the benefits of having the anonymity, the Wyoming law, and the asset protection. Now you have a growing portfolio. So you have your holding company and you have 3 properties that you bought. They could be in one state, they could be in 3 different states. And you typically, everybody will tell you, if you are an active owner, you don't, this again is a choice, but again, to me, it seems like a no-brainer. Every property should be put into a separate LLC. Depending how big the property is, some people could say, look, up to $1 million, if you're buying small properties, $100,000 each, you could say, okay, I'll put 3, 4, 5 in one LLC. It's okay. It's only $500,000 if that's good with you. Or you can put them in separate, or you could put every single property into its own LLC. But at some point, you have to understand that all the properties in one LLC are subject to the liability of the entire group. So if you have 5 properties in 5 different states and they're all in, well, in different states it won't work, but if you have 5 properties in one state and they're all in one LLC and somebody sues you in one of the properties, the creditors can come and take away all 5 properties from you. So you really want to segregate it. How you segregate it, how you isolate them, that's a choice. That's a financial economic consideration, how much money you want to spend on LLCs and how much risk you want to take. But here's something that's very important. One of the most important rules of asset protection when it comes to LLCs are you want to separate your risk. You always want to pull out your risk from the LLCs that are holding assets. So if you have LLCs that are holding expensive properties, $500,000, you want to draw all the fire and fury away from those LLCs. So for example, you want to hire a property manager. If you have a property and you have an LLC, it's property manager LLC, and he's in charge, that company is in charge of servicing, collecting rents, servicing these properties. Now, if anybody's going to sue, their first line of lawsuit is going to be against the property manager. And therefore, the property manager will not be carrying very many assets in the LLC. You're just going to have some operating capital, nothing more than that. So that's a great place. You want, again, it's like a decoy. You draw the lawsuits to a place where you don't have any assets. Another reason why you want to have a property manager is if you are the property manager, people will think that you own, or they won't think, they'll know that you own the property. But if you have a separate LLC that's a property manager, then nobody will have any idea who owns the property, and a disgruntled tenant will not automatically, if he's angry at the property manager, won't place you as the property manager and go sue your properties. Okay, now we have a joint venture and we have operating partners. So we have 5 different people. Each one has their own superpower. They want to get together and buy a property. So what they do is they don't form a single member LLC. Now you have a multi-member LLC. Now, LLCs have 2 choices. They could be member managed or they can be manager managed. The default is member managed, which means every person who is a member of the LLC has equal voting rights and equal decision-making responsibilities or capabilities in the LLC. If the LLC wants, they could designate one person as a manager, or 2 people or 3 people, whatever they want, and they could, then it becomes a manager managed LLC. So typically a joint venture means that all the people actually want to contribute. That's why it's not a regular LLC. They all contribute together. The vehicle that they'll use will be an LLC, and they become equal partners. Typically it won't be more than 5 people, because for 5 people to have decision-making powers and get along and get something done is rare. More than that is probably impossible. The partners don't necessarily have to be people. They can be LLCs, they can be groups, they can be anything. There's no fees. There should be no management fees to one partner or the other partner, because again, they should be equal partners, and the profits should be split equally. So you have all these partners that become members of this LLC. We call it the joint venture LLC. Joint venture is not a business entity. It's just an LLC that's set up as a joint venture, and that joint venture owns property. Now we have a syndication structure. So syndication is your typical deal where you have a general partner, they raise money from limited partners, and in an LP, as we said, it's very simple. The general partner has all the liability, the limited partners have no say. All they do is give their capital, they have no control, they have liability for the liabilities on the GP, and the GP is an LLC, right? The GP makes himself an LLC because if not, this GP over here is going to be personally liable. But if the GP is an LLC, then they can only sue the GP. And together they go ahead and they buy a property, and that would be a LP structure. Now you can have an LLC structure for LP, for a syndication. Now let's just go back a second. When it comes to the LP, the general partner, he's the asset manager. There's no need for another entity. When it comes to an LLC, we can structure it that you have the class people, they're passive investors. You can have class B, which is the management class. And what they have is they have not the same distribution. They put in less money and get more returns. They have more voting rights than class A. Class A may not even have voting rights, but they're still regular members of the LLC, okay? And then you could have the uneven split, non-equal voting rights. You could have it manager managed, and the class B could be the managers, where the class A are just members, non-managing members. And then here's the feature that you can do with the LLC structure. Again, as we spoke about before, you designate a separate asset manager. This asset manager is not part of the LLC. It owns no shares of the LLC. It just gets paid for being an asset manager. And again, just like the property manager, when you have one person that has a portfolio, we direct all the fire at the asset manager, whose liability is very limited because they don't have any capital in the LLC, or not enough capital to make it worth anybody's while in the LLC. Now, this is something interesting that is not usually done, and it may not make sense to do it, but there is such a concept. The class A managers, they will probably, the class B managers will be sued. Okay, they will be sued no matter what happens, but obviously they're second line after the asset manager, and they're more protected, and they can say that it wasn't their responsibility. So the Class B managers don't necessarily want to take all their shares as Class B managers because that puts it at risk. So the Class B the managers split up their shares into Class A, where they get the same exact rights and distribution as the other Class A members. And then they keep only the extra for themselves as Class B. So if they're sued as Class B managers, they can still get off the hook with these Class A shares that they have together with the other passive investors. So this is the manager's passive shares. Okay, so if you have a syndication that's multi-property, you can have two things. What you could do is you get a syndication together and say, okay, we're not buying one property. This is not much to add over here. It's similar to the other syndication, but you decide, you have a list, you say, okay, we'll be doing 3 properties. These are the 3 properties that we'll buy. They buy a portfolio or they buy them one at a time, and they're invested in all of them. This way they don't have to go out and start raising money for each deal. Now, if you want to get even more aggressive, you can have a blind pool. You can try to raise money and say, look, we have 20 years of experience. We're looking in this market for this type of asset class, and we want to raise money because we need $20 million to buy X amount of assets. So you put in a blind pool, and it would be the same structure. You have the Class A investors, Class B managers, and they buy as many properties as their syndication is set up for. And again, you have the asset manager over here. Now, when you have a syndication for development, we're not talking about buying a building, we're talking about constructing a building. So here we get a new feature. If you'll notice over here, this is pretty much the same, but we have a new SPV over here. And SPV is just another layer. It just means special purpose vehicle. The syndication will not own the construction project directly because we want to keep the syndication away from all the problems and complications of construction. So we put between the two a special purpose vehicle, and the partners to a development project will be the syndication plus the developer. The developer will first start the SPV. He will get all the permits for the construction to whatever degree he wants to move it forward until he wants to raise money. And then he'll sell part of the SPV to the syndicators. So in the syndication, you have no direct ownership. The developer forms the SPV, and then the developer manages the construction project. Now you have a joint venture that's not a joint venture between equal people. It's a joint venture between an operator and a capital partner. Now that could be a family office. These are heavy-hitting capital partners that typically for very expensive deals, and the capital partners in those cases they ask the moon. Okay, the operator, it's a last line of resort to raise capital. You prefer to have your own investor network, but if it's a very high sum and you need the money, then you can get a capital partner. The syndicator will do a JV together with a capital partner and buy the property. In these types of arrangements, they're typically more than $4 million because less than that, you would just go out and raise your own money. You wouldn't go to a capital partner. The JV becomes a multi-member LLC, which become member managed. The capital partner has a say, the operator has a say. That's why it's a joint venture. They'll give operating incentives. So the operator will get incentives in order to manage it well, but the capital partner will have a liquidation preference. He'll get his money out before the syndication. They'll also want very high return promises and a low hold, 15% over 3 to 5 year hold. The capital partner will make you pay legal fees. They'll put that on the syndication. They will not pay the legal fees. If there's a breakup fee, if the deal breaks up before, they're not paying anything. And if you don't meet certain hurdles, then you can forfeit, they can make you forfeit your entire share of the property. So as a limited partner, if you go into a deal with a capital partner, this is how people lose money, and they don't understand what's happening because they don't know all the clauses. And that's a classic deal where you can lose every penny. I think this is the last one of this one, and then we have a couple other entities that we'll run through quickly, and then we will wrap up. Okay, so we have senior assisted living. Senior assisted living is because there's two parts of the business. There's the property, and then there's running a senior assisted living, which in itself is a valuable business, but it's a very high risk business. So in line with our rule of asset protection, we break up the property company, the propco, and the operating company. This way, the operating company, if there's any problems, they get sued. The property company, they still have their investment in the land. So you'll have your investors, you have the syndication, they'll buy the land through the propco, they have the opco, and the opco will lease the land from the propco and run the assisted living. Okay, let's just recap some of the guidelines for how this works. The first thing you want to do is you want to limit your liability, keep your property segregated to isolate liabilities. For capital raising, if it's high, you want to create a separate SPV because the lenders will not want to lend directly to a syndicate. They'll want to control it through a SPV. And for asset protection, you want to pull out the dangerous parts of the business in order to have them as separate entities to protect you from any lawsuits. Okay, there's some other structures that are non-standard structures, which again, we're running out of time, so let's do this very quickly. The first one is a fix and flip. Now, a fix and flip will usually use an S Corp, and the reason is because a fix and flip is not capital gains. As we said, the only time you want to use LLC is when they're all capital gains, so you don't have to pay self-employment taxes. But when you fix and flip, you're not investing in real estate. You're a dealer. You're buying a piece of property and selling it. So you're no different from somebody buying watches and selling them or shoes and selling them. You have a regular business, which means that it's not passive, it's active income. So if you were just a regular LLC, you would be taxed on, you would have self-employment taxes on the entire amount. But if you're an S Corp, you can give yourself a salary. I don't want to go into this now. It's not important because these are, because this is fix and flip, but there are two different structures that you can use. Whoever wants the slides at the end, just let me know and I'll send you the slides and you can ask me any questions you like. 1031 exchange. This I want to go to, I want to talk about it a little bit more because this is important. When you do a 1031 exchange, you get to sell your property, not pay capital gains tax if you take all the money and then buy a new property with it. There's one catch. The catch is that the person who sells the property or the entity that sells the property has to buy the property. So let's say you have an entity. Let's look at this one. You have JJ LLC that owns this property called Main Street, and they're buying Central LLC. Now, Main Street is selling, Central LLC is selling the property, and Main Street is buying the property. These are two different LLCs. So how does that work? How do they get the 1031 benefits? The answer is that JJ LLC, LLCs are pass-through entities, and we don't look at it as one central LLC as the taxpayer. JJ LLC is selling and JJ LLC is buying. Therefore, we cover the rules of 1031 LLC exchange. So the reason why I'm telling you this is very important. When people buy property, it's better to have some sort of holding company in order that you could do 1031 exchange. There are ways to do it without it, but you just complicate it and it will cost you more money at the end rather than setting up an extra LLC to handle your 1031 exchanges. Okay, let's say, and this one I want to also cover very quickly. Let's say you have a syndicate. So you have 5 people in a syndication that own this property, but they don't want to all sell and buy another property. They all want to go their own way. So the way to do it is instead of buying it together, they can each buy a separate tick. That means they're buying only a percentage of the property, but they are sole owners. There are a lot of rules to how to run a tick. It's pretty complicated. You need a tick agreement. That's why most people don't do it. So they'll buy it as a syndication. And what they'll do at the end is, right before they sell the property, they'll transfer out everybody's share to their own tick. And therefore, when they sell, each tick will sell by themselves. And then each tick can then go back and buy their own property. Again, if this was rushed through and unclear, just let me know. But I really want to finish within the hour. Estate planning. This is something, it's just a hint. We've done a series of webinars till now, and we may do one on asset planning, asset protection. So just quickly, there's something called a revocable trust. You can have, because you still have, if you have an LLC, there is charging orders, and people could get to the LLC. They can only take the distributions. If you want to protect that and pass the assets along to your children without anybody getting a hold of it, you can make a trust. And if the trust is only to your children, then they're the only beneficiaries and it's not revocable, then none of your creditors can take away that trust property. There's a Nevada asset protection trust, which I don't want to get into. I think we spoke enough for today. I hope it wasn't too much or too quick. So I just want to tell you a little bit about NUCO Filings. We are expert assistance with LLCs and CTAs, or beneficial ownership of the CTAs, the Corporate Transparency Act. We file the BOIs for everybody for FinCEN. We have a fantastic LLC portal, which you don't have to have all your LLCs with us to use. You can have LLCs with any provider and still use our portal for free. We can track and update the BOI reports, which you cannot do online with the federal government. And very importantly, we're registered agents in all 50 states. So when you go do deals in different states, we're there for you in every state. Most people we know have different registered agents in every state, and it's not a healthy situation for management. And if they don't pay the registered agent, then their LLC can be taken away by the state, and that causes lots of problems, which unfortunately we deal with on a regular basis. Thank you very much for joining. If you have any questions, feel free to just email me. You have my email address and my phone number. You can call me, you can email me, and I'm happy to answer. Again, thank you. I hope this was helpful. I don't know if this was overall helpful, if most of the stuff you knew, but I hope everybody got at least one interesting piece of information, and I hope it was worth your while. Thank you very much. Have a great day.